Breaking news. Welcome to today's headlines. Lawyers disagree on CJ's power to direct secret trial of terrorism cases. Lawyers disagree on CJ's power to direct secret trial of terrorism cases. To my dear listeners from wherever you're listening from, please stay tuned as I read today's news. Nnamdi Kanus with his lawyers during a recent sitting at the Federal High Court, Abuja. Legal practitioners are not on the same page with regards to the new Federal High Court Practice Direction 2022, in which the Chief Judge, John Itoho, strictly prohibited coverage of terrorism proceedings except as approved by the court. The direction, which was issued to the Whistler on Thursday, states that terrorism cases shall be heard in camera, that is, in private, before the trial judge and in absence of the press. The CJ, Chief Judge, had said that the approval is based on his constitutional powers, as enshrined in Section 254 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The new rule was made public a day before the ruling on the application filed by the leader of the indigenous people of Biafra, Nnamdi Kanus, challenging the competency of the 15-count terrorism-related charges instituted against him by the federal government. Justice Binta Uyako had struck out 8 of the 15-count charge, while adjourning to May 16 and 28 for ruling on Kanus' bail application and continuation of trial. She also made it clear to counsel for the respective parties that she is going to explore that opportunity in the new practice direction, vice versa, the infraction the matter brings on other courtrooms, as well as the security implication it imposes on the road leading to the court. But constitutional lawyer Festus Oguche told the Whistler that the constitutional requirement for open or public trial can only be abridged in the manner prescribed by the Constitution itself and not through a practice direction as done by the CJ. He opined that the trial court should be wary of infringing on the fundamental right of people and the press, who are supported by international instruments to observe proceedings. It is a grave misnomer that a mere practice direction would be applied to alter a notable imperative for a fair trial under the Constitution, and one wonders if our jurisprudence is geared backwards. You may change the venue of judicial sittings or put in place security measures that may restrain free movement of individuals on days that such matters are slated, but definitely not by practice direction that seeks to circumvent a fundamental right is stated. He further argued that only constitutional amendment can guarantee several sections in the new practice direction. The Chief Judge of the Federal High Court ought also to have put into consideration the fact that the requirement for a public trial is one entrenched in several international human rights instruments as global standards of criminal trial or adjudication, and I seriously wonder how his practice direction would impact to render the guarantees under the instrument impotent. Not in that circumstance, not even the National Assembly can make such law, as it clearly lacks the capacity legislatively unless the way of a constitutional amendment. But then such amendment would also be an uphill task considering also that the legislature cannot make law that impinges against the fulfillment of the country's international obligations, he added. Oguchi recommended the immediate withdrawal of the new practice direction as quickly as possible and save ourselves serious embarrassment before the Committee of Nations. However, Oluwaleke Atolagbe, an assistant counsel International Criminal Court, Hague, told our correspondent that he does not see anything strange with the new practice direction on the prosecution of terrorism cases because Section 254 of the Constitution of the Federal Republic of Nigeria 1999 as amended expressly empowers the Chief Judge of the Federal High Court to make such practice direction. He also stated that the direction is in order because Section 232 of the Administration of Criminal Justice Act provides thus a trial for the offenses referred to in subsection 4 of this section may not, where the court so determines, be held in an open court. To my dear listeners, now I've come to the end of our today's news. Please do drop by at the comment section and let us know what your view is all about. Thank you for listening.